we start? Rahul? Rahul?
I said start.
Okay. Thank you. Welcome, everybody, those who are here. Good morning to the friends from Caribbean. Good afternoon to our friends, those who are in Africa and Europe. And good evening to our friends, India, Bangladesh, and Far East, Australasia, Asia Pacific. Today, on behalf of Jitendra Mohan Sharma, on behalf of Nivaran, the Supreme Court Mediators Group, welcome you to this webinar. Supreme Court Mediators Group, the Nivaran, has been active in continuous legal education in mediation. And this way back in 2020 earlier, we started a physical seminar, talk in the presence of our then committee chief, Justice Call. And as the pandemic came in, which we really utilized it, and the opportunity which it gave us, that in place of having our physical meeting, we started this webinar series. Nowadays, the Supreme Court Mediators Group Nivaran is organizing webinars in twofold. One is an international series along with Commonwealth Lawyers Association and our partner Youth Bar Association for the younger lawyers and students. And with them, we organized a summer school for young students also with regard to mediation, to promote the concept of mediation. With our international partner, Commonwealth Lawyers Association, we organized specific subject-oriented webinars, like specifically on sports law and an all-female mediators webinar, which was presided over by a sitting judge in Supreme Court. Now today, we are starting another interaction with our close neighbor, Bangladesh, where the mediation process has already begun. And the mediation process is taking over as an alternative dispute resolution mechanism. And one of our pioneers at Bangladesh, Justice Muhammad Abdul Halim, he's a judge for more than 2 decades and has been pioneering this mechanism and this movement of mediation in the Bangladesh judicial system. Judge Halim is a trained mediator, and he has done his training in US and has been a regular participant in seminars. Now, the object of today's webinar or an interaction is to have an interaction amongst the Indian subcontinent, which is of which Bangladesh and India are part of it, how the mediation movement is going on. The mediation, in fact, the concept of mediation, of a reconciliation or a resolving a dispute at a lower level amongst in the villages or at the lowest level, was very much prevalent among this subcontinent. That was a loosely termed settlement, which we possibly known as, those who are there, this is the panchayat system. Which panchayat system is a loosely associated of today's mediation, conciliation, and arbitration. The panchayat system was basically to where the elders of the village sit. They want to resolve the dispute, and at times they used to peer pressure also and other exercises also. Those influences were exercised. So that concept was very much a mix of mediation, arbitration, and conciliation. While today's mediation, what we are going for it nowadays, the mediation is an absolute system, a process by a neutral individual who is being trained to assist the parties, to help the parties to arrive at a negotiated settlement, to help them to arrive at a settlement. So the parties may arrive at a proper settlement. The settlement could be between the parties, because if a mediator feels like he has to be a neutral, and the concept of confidentiality, and that's all what we'll be discussing about. And I welcome Judge Halim to be there. Judge Halim.
Yes.
Judge, are you there?
Yes. Good morning, good afternoon, good evening to the audience who are watching us, hearing us from the various parts of the world. This is Judge Halim. My full name is Muhammad Abdul Halim, but commonly known as Judge Halim. That's why on the screen you see Judge Halim. So I am a district judge. I am a district judge in Bangladesh, and as usual I am from Dhaka, Bangladesh, and very close neighbors of India. All the audience know. So I am working, as little intro from my side. I'm working as a district and session judge, and my work experience is 23 years running, almost 23 years, right? 22 years of running. So this from my side, and apart from my job, I also do. I'm trying my best to develop the concept of mediation in my country. And educationally, I am graduated with master honors and masters from the University of Dhaka, and then did my second masters Loyola Law School at Los Angeles, USA, and I'm the senior fellow of GEMS, located based in USA. Apart from that, I have some mediation training based in San Francisco and Los Angeles also. This is a little bit. From my side, I want to start from my side by saying that mediation concept is very new concept in Bangladesh, right? And it is a mixed up in judicial process, right? Judicial system. So judicial mediation, is to have the concept like this. If I if I say like this, is a having adoption of the mediation alternative dispute resolution system in judicial process, right? So
I just want to ask you, when this concept of mediation was introduced in the judicial system in Bangladesh?
Understand. Not very long years. It's so far as I can remember, it is 2007, 2007 maybe. Is our radical change is by inserting one or two sections in CPC, 89A, right? 89A. It was not earlier, but it was 27. It has been maybe like this, 27 or like this. It has been inserted, and further we have a family code ordinance, but it was enacted in 1985. There was two sections. There were two sections in this family code ordinance. Broadly name I can remember is section 10 and Section 3 with the word of it's a pre-trial and post-trial, right? So these are the but major changes in when the CPC has been amended, right? So it is not for it is from 2007, right?
So prior to this or before it, after coming it, do you see the change coming up with this concept coming up after this there in the judicial system?
Yes, yes, yes. Some changes has been occurred, right? I see some changes because suppose for, 10 years ago, the stakeholder doesn't have any idea at all. But nowadays, the stakeholders have ideas, some ideas, and the lawyers, some of the lawyers have set their minds right about the mediation system. So I think it is developing, right? Although it is slowly, but gradually it is being developed.
Oh,
Definitely, it is being
movement
developed.
always takes its own pace. Movement can't be.
Yes, definitely. Yes, yes, yes.
There is an African proverb which says if you want to move fast, move alone. If you want to move together, if you want to move further, move together. If you want to move
Exactly,
alone,
exactly.
move fast.
So,
So the movement takes its own pace.
We are moving all together, right? So
Right.
for sustainable development.
That is more important. That is more important that the mediation concept is being accepted by the Bangladesh as a judiciary, as a litigant, and those who are going for it. The concept which has been introduced.
Right. Yes. Yes.
Since you are a pioneer and since you are introduced, you are a founding member of Bangladesh International Arbitration and Mediation Center.
Yes.
So, what type of litigations are there?
Well, it's a multi nature, right? Family matters come here. Family matters. We have basically I have 20 young mediators who are working, who are being inspired by me. You know, as I'm a judge, sitting judge, so I have some limitations definitely. So they work exactly right under my guidance. I guide them right to work. So they have some cases like from family matters, some civil matters also, and they recently they pointed me that they have some cases from abroad online. It's also it's a partition cases, something like this partition problem, family dispute also we should say. So there is a dispute between among the family members regarding the partition of the property, and also some uh, uh, mis misuse of money which has been the Bangladeshi people who live in foreign country. He sends the money to his family. That family sometimes misuses money. Suppose the father of the family, or right, the brother of the family purchase the property in his own name. So in a like cheating, right? So they come to BIMAC and to online the solution like this. They contact the family members. What is happened actually? This like this, but it's not broadly, not broadly, but it is getting more and more day by day. Is more cases.
Right. That's
What remarkable.
In fact, in India, it is started. There was a judge by Supreme Court. There is an Afghans infrastructure. There is a judgment in Afghans which states that mediation is ideally suitable for certain category of cases. And the category of cases, if she said where there is a relationship is involved. Relationship is involved, say like that relationship there could be a family relation, the matrimonial. The B could be where there is a family dispute, the brothers, sisters, uncles, nephews, the family dispute, the partition, wherever the relationship is done. Third could be between tenant and landlord, the relationship, where the relationship is important. Or a purchaser or a seller, where the commercial dispute arises. Say like there is a principal and its agent, where the relationship is more important. However, it said that there is a restriction. It's ideal in those situations. It said that it is in say like criminal offenses in so like the serious nature, which are an offenses against the public. In such cases, court said that mediation is not effective and it should not be exercised because it would be the criminal jurisprudence. That restriction is there. But the AFCONS is it is the 2010 SCC. That is an AFCONS. I can give you the citation also if you want. Yes, this is. Somebody want to note down. This is 2010 8 SCC, 8 Supreme Court cases, page 24. AFCONS Infrastructure Limited.
Good. Very good.
So it has given a broad distinction in which cases where it is an ideal and it can really help. Mediation can really be effective, very effective.
Yes, I can add with you. There's same scenario in my country. Like we have some specific case like this bank loan. It can be right. But family courts, I already pointed out. Civil cases, I also pointed out, and this is a VAT and excise tax excise cases. VAT and excise. Okay. That is the another jurisdiction where mediation can be exercised, right? And very recently, one of our honorable judges from the High Court Division gave a verdict with the observation, and which is now being followed by our lower judiciary in criminal cases. We have a tribunal to try some cases originated from family matters like this. We call it women and children. In Bengali name is like this, or Nari or Shishu Nirjatun Daman Adalat, is meaning women and children anti-abusement act, like this. Okay. If I want to say in English like this. So in that cases, one of our justices of the High Court Division made it one section like this when the matter is dispute between the husband and wife, likely like this. The husband complains like this. The husband wants much dowry and expel her from the husband's house. In like this, it's a very common scenario in our society. And women, many cases goes to the court with this allegation, right? And what is seen after the trial, that maximum of the cases are false. No, false, or I should say cannot be, right? I should not say false. It cannot be proved, right? That's why our one of justices of High Court Division made it that conciliation is a must. At first, conciliation or mediation, like what you say. So it's a step must be taken between the husband and wife on outside the court, and the court gives them time, right, with the supervision of the concerned advocates, and the advocates in that time, they tries to resolve the dispute. Like although it is a criminal cases, but very heinous cases, it is impossible, like murder, right? Like this. So it is impossible, and it should not be, right?
Yes, it should not be there, because against the public justice, the mediation should not be.
Yes.
Judge, I just want to ask you: are there any statutory provisions also in Bangladesh to support mediation?
Yes, we have. Yes, definitely, we have some statutory provisions in scattered way, I should say, because already I gave some examples like CPC 89A-B, right? So there is a provision in a whole CPC. After the filing of written statement, the court shall try to resolve the problem, like resolve the dispute by mediation. This is a provision, right? So there is a provision. You see, there is a provision in CPC. Also, there is a provision in family code. I earlier pointed out section 10 and section 13. Postal and pretrial, in the name of postal and pretrial, but is a mediation, right? So you see there is a case. There is in another law in my country, it's a it's a money loan cases. It's basically bank loan cases, right? So when a public takes money from the bank and is not paying, so bank has to has to file a case, and the case and the where the case is filed, there is a specific court right there, right? And there is a specific law is there, and there in that law there is a provision for resolving the problem, resolving the disputes by conciliation, mediation, like this, right? A discussion based, right? Okay. Besides that, we have arbitration tribunal, arbitration case. So arbitration tribunal is a separate law, and scatteredly we have some other provisions like this. But what is happening here? Not consolidated, right? One like this Alternative Dispute Resolution Act or Mediation Act or ADR Act or ADR rules. There is no law like this. What I have seen, many state of India has some rules like this. I can now give an example like Hyderabad, right? They have formulated a very good rules governing the mediation and alternative dispute resolution. And the heading of the roles, alternative dispute resolution and mediation roles. And I love it too much. I was astonished 2 days ago when I was reading these roles. Everything is there. Who will be the mediator? How the mediation firm is going on, how formed, who will be the mediator, how they will be trained. Everything is there. So I think you the guys of that state are lucky enough. And I should say I believe all other maybe all other states of India has some rules, as India is tremendously doing good in mediation sector, and I appreciate, I love it, and I basically become
Thank you
very
so much.
fan of Indian mediators.
Thank you so much. Thank you so much. Thank you so much. Thank you so much. In India, the provisions regarding mediation, in fact, there was a loosely reference of mediation was already there in way back Industrial Disputes Act. There's a conciliation between laborers and the management. And then it went on an arbitration also, the 1940 Act, there is a little provision, but not so, there was loosely. What it came exactly was in 1996, when there was an Arbitration and Conciliation Act. So initially it was the name of conciliation. The Arbitration and Conciliation Act 1996 gives the provision for conciliation. Mediation was still not known. Even like West, where there is a concept of conciliation is going, which is used at times as in for mediation. But nowadays in India, we have made it very clear. There is a distinction between a mediation and a conciliation. Conciliation is a process where a person, the conciliator, considers everybody's, both parties, is neutral, confidential, all those are there. But he has got one more part, he can give his own suggestion also. A solution, a possible solution, which parties may accept, may not accept. That's a conciliation. But while a mediator can do all things, helping it, but he cannot give a suggestion.
Right.
Because it has been found that when a mediator gives suggestion about a possible solution, then his neutrality or his confidentiality is jeopardized. So therefore, the mediator only helps parties to arrive at a settlement. He can give individual to take a view, and that's how they are being trained. So that's a difference was there. But anyhow, in 1996 Act also, there was a provision which states that parties can arrive at a settlement, and then an arbitration award can be passed. And an arbitrator can also act.
Right.
However, the moment for mediation really came up after there was a provision, an amendment in Section 89 Civil Procedure Code with regard to, under the Family Act, Court Act also there was a provision, and still they used alternate dispute resolution. When for the first time it says that there is a arbitration, mediation, or conciliation.
Yes.
There is a loosely of Lok Adalat concept also. Lok Adalat is a very novel concept, which is being absolutely for an Indian subcontinent only. Here, there is a government, the judges form a Adalat which is called the Lok Adalat. Lok is the public and Adalat is a court. Now the judge holds that in the open where the client is directly interacted, and possibly it helps out in resolving the dispute. And it has been very effective with regard to motor accidents claim. There are a lot of litigation is pending with regard to motor accidents, motor accidents claim. So that Lok Adalat has really helped in resolving the disputes of motor accidents claim, because there it did help. Then in 2005, around 2000, early 2000 was a beginning of mediation movement in India. The Supreme Court played a very proactive role. And Supreme Court formed a mediation, conciliation and project committee. And which was to be, a committee was formed between 2002 and 3 and 4. And there was a Chief Justice Lahoti. He formed a mediation and conciliation project manual, which is a guideline for all centers, and they started accordingly. Now that manual indicates what is a mediation, what is a concept, what litigation should be referred to it, how a mediator could be trained, what are the norms, what are the confidentiality, what are the training is required, and they made a mandatory training of 40 hours.
That's good.
Now that 2005, that's a manual. That's a huge book, the guidelines of about 200-300 pages. All the mediators, the senior mediators of the country, they put their head together along with the judges, and it had the long sittings. And thereafter, that manual was formed. It is only thereafter, after that, it has started. We are having a individual centers. Since Supreme Court is a apex court in the country,
Right.
but the highest court of the state is High Court.
Yes.
So in India, there are different centers, mediation centers are being created in different parts of the country. Say like earliest was about at Bangalore, Chennai, Gujarat, Ahmedabad. Ahmedabad is considered to be one of the earliest, but over a period of time it started. And Delhi, which is possibly a slightly younger one, but the younger has got more energy and enthusiasm. So it has moved really far, and mediation process and the mediation centers are really working on that. And they themselves have developed their own rules. Now, the recent development which came up with this pandemic, till now, all the centers before 2020, all the centers were operating and they're working with the physical sessions, with a few exceptions, with the 1 or 2 exceptions where there is a client is abroad or our parties are not able to come. They used to have there was an exception. But after 2020, when the pandemic broke, then virtual came out to be as a perfect mode. And then they realized, then all the centers developed their own rules of virtual working of mediation. The rules were how the confidentiality could be at stake. There is parties have to be made sure about this virtual session. If a virtual session is being done, there has to be a definite newer rules than what the rules are required for the physical hearing. And now recently I've come across that there is a training program also in a virtual mode. Now there is a 40-hour training program, which is being conducted for on a virtual mode only. So in that case, statutory provisions are there, and it started because Supreme Court took initiative and it percolated downstairs. And very recently, there is still litigation pending, though we still don't have any statutory provision with regard to mediation, but it is only Supreme Court's And there is a one more aspect, which is pre-litigation, before litigation. Very recently, the legislature was wise enough, and regard to Commercial Courts Act, there is a Commercial Courts Act and under the Companies Act, there is a provision which they introduced with regard to pre-litigation. Before going to a court, you must have a mediation, and after mediation failed, only then you should come to the court. So that's the one which is going. But then we are working, we are all learning the process. And this pandemic has really
perfectly you told all the matters, and I was listening to you with my astonishment how India is developing, right? It's already developed in a system, in mediation system. So we now from my side, our one of justice is very concerned in the matter, and he is giving some training to our judges, right? To judges online in the COVID situation to prompt to prompt mediation system, and I think it will work. It will work when court resumes. So if the mindset of the young people, young judges, right? Because we are the senior judges in lower judiciary, so we don't have actually filing cases. We are not supposed to handling the filing cases. We are not the filing judges, right? So the filing judges is up to joint district judge in my country, so they're the younger one. So my respected my honorable justice is doing perfect thing to giving them training to the young judges, right? So who are dealt with the cases. I had the appeal, right? Appeal like this, but we have no original jurisdiction. That's the problem. So the youngest one or the young judges would be the mastermind of developing the mediation system in my country, and the efforts is being made. Efforts is being made.
Thank you, Judge. That was exactly my next query. I was going to ask.
Yeah, definitely. Most welcome.
How the judges in Bangladesh respond to this concept of judges, because
okay. Okay, thank you very much. Very important question. As I'm being I own the judiciary, so it's a very
precisely you are the right person to ask.
So earlier, if I go back 20 years ago, in that time exactly the judges don't have any idea about the process, right? And even they never thought of this process, that it may happen. They never thought of that. But the passage of time, and as the mediation process is very fast going in the other part of the world, so our judges become very interested to accept the idea, right? Personally, some of judges not yet set up, but maximum of the judges, they want, they try, they want. But what is happening here is that there are pardon of cases, I should say, because you will be astonished how many cases are pending here. It is almost 3.8 million, 38 lakhs cases are pending. So suppose one assistant judge or district judge is a entry level and mid level judges or the filing lawyer, having original jurisdiction, right? If they can the ideal counts is that they may have 400 or 500 cases. So if he has 400 or 500 cases, so he can try very good, right? But the matter is that he has been burdened of giving him 2,000, 3,000 cases, civil cases, right? So when a judge is to handle, suppose 50 or 60 cases in a day, and he has no time at all to deal with deal with the mediation process whenever comes in the judicial proceedings system, right? Judicial system, that is after filing written statement, the stage is like this: trying to mediation. It's a mediation step, right? So when the case comes this stage, the judges, two options. The judge can, yes, the judge can take the matter seriously, and the judge uh, take it may take it very loosely, right? So what our judges do? Our judges try, but due to constraint of heavy workload, it is not possible for them. It is not. But I talk many of the young judges, they are very interested. Although most of the senior judges, sorry to say, that, maybe my judges, senior colleagues are listening to me, but I'm telling the truth. Many of the senior judges, senior to me, like they have the negative idea about mediation. When I talk to them, they say, "Oh, it's not working at Bangladesh. It is a British process. It is an American process. So it is not working here." Then I try to understand them. No, sir, this is the process, is well settled process in all of the world except this country. So you please try to understand this is the process. You can try, and if you can try, and if you come, if you can settle even a case, and that will be the best option. That will be the best solution for the parties, because they will never come to the court after the resolution through the mediation process. But I make them understand. Sorry, I'm taking time.
No, 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 no,
Sorry.
no,
I
no.
make them understand. I try to make them understand that
Yeah.
if you don't do that, and if you go to the litigation system, you may give a judgment, but this is not the final judgment, and final verdict must come from our Supreme Court, apex court of the country, because before coming any decision from the apex court, the party winning in your court, in the lower court, cannot have the chance to say that he is the winning party, because the option of the appeal is open to the losing party. So, now what should I say? It's a British colony. We are the British colony, like you. So the oldest, right? Oldest, very slow to accept the changes. But nowadays, the situation is being developed, and many of the senior judges also change their mind, and it is very hopeful. Change their mind. Because if 5 years ago I talked to him, now he said, "Oh, no, it's a good system. It's a very good system. Halim, please connect me." Even they say me, even tell me, "Halim, you are the pioneer in Bangladesh. So you are we understand. After the retirement, you are going to go there, do new profession like this. Please take us with you." Oh, sir, what are you doing? So it is definitely, it is positive sign
Right.
when my seniors
Very good.
have changed their mind, right? It is definitely, and also the young are very acquisitive, and very positive
Yes.
minded. So I'm very hopeful, right? This is the response of the judges, yeah, as per your in response to your query. Thank you.
Yes, yes. No, you are right. We also face the same problem. In earlier, I've been associated with this for almost about 15 years in the early stages.
Uh-huh.
So initially, when there was a movement, I recollect in district courts, the lawyers resisted. First of all, the lawyers resisted,
Yes.
as if they could take a different one. But then the judges also had the same frame of mind. But fortunately, the
Yes.
judges of superior court, from higher court and from high courts,
Uh-huh.
came to our rescue. They understood the concept, and they really
Yes.
conveyed the message. And then once the message is being conveyed from the top, it percolates. And when it percolates,
Yes.
that steps. So
Exactly.
resistance is always there. Always it comes to a new change. Of course, in Western jurisdictions have also faced. They faced this resistance a little earlier. So that's not a new thing. So resistance is there, but gradually now, fortunate for India, nowadays it is there going on, and even so much so. I tell you about the activity, how active this proactive the courts are. there is a petition being filed in Supreme Court which says there must be a pre-litigation mediation. There must be throughout the country, there must be a direction that there must be a district court headquarters. From high courts there are there. Now each state has got one high court, but there are almost about 30, 40 district centers.
Yes.
The litigations emanate from that place. So if you want to convey the benefits of pre-litigation mediation,
Yes.
that has to be there at the district headquarters center, and Supreme Court is taking part. And it is asking government what you are saying, what is going on. It is still pending.
Yes. Yes.
So that is there.
I can add one point with you for my audience is that we have a body to conduct the mediation process, judicial mediation process, right? Its name is Legal Aid Service, right? The government has we have 64 districts now, so every district has a legal aid office, and that legal aid office primarily was set up to provide legal aid to the needy people, right? That means by helping in terms of money or by helping them engaging a lawyer like this. But 4 or 5 years ago, this officer has been empowered to mediation to do mediation work also. So some cases, family cases, when judge refers these cases to the its name is still legal aid office. And once one of my occasion in this platform, I asked one of the director of the legal aid service, sir, this is a mediation center. You tell it like it is a mediation center. Why not? It is named mediation center. Why it is still legal aid service? Because when you say this legal aid service, people think that it's an office providing for the needy people only. But the people don't have an idea. This office works also mediation process, right? So it names should be like this: legal aid office and mediation center. If it is mediation center, so it can be easily understandable. It is visible. So
Yes.
how the cases comes to this mediation center is a question. Sometimes the judges send the cases there, and sometimes the people who have knowledge about the legal aid office, they come to court for some advices, what should do, and when they come for advices, our legal aid officer entertain them, right? What's the problem? Oh, now this is the problem, you can solve like this. You don't need to go to the court. Okay, I am summoning him. Okay, let have a discussion, right? Like this, like this. Very little bit what, but they're doing still good. I mean, and young officers are posted there. So I see they work much. They work much, and they resolve some cases. But in comparison like that, it's a few in comparison to the total figure. But personally, individually, he or she may dispose of lots of cases is another thing. But in comparison, this and mainstream means civil cases is not being is not being settled in mediation process in legal aid. It's very uh, hard to
Yes.
many reasons like this. Main reasons like this, civil cases are more complex, right? And it is presumed that senior civil lawyers are engaged in those cases, and these civil cases are being conducting for many years. So, so experienced lawyers are always involved in the critical civil cases.
Yes.
So the officer who is have only 2 years or 3 years experience, if he is posted there, it's my personal thinking. He may not have the position to mediate the cases with the senior lawyers, like because it's a mediation is a I think it's an art, it's
Yes.
a technique. It is
Yes.
not like that is that I am mitigating in the parties
Right.
like blah blah blah. Like no, it's a trained process, it's a technical process, and although it is said that our mediation process is very easy, but it is not easy process. It has some rules, it has some techniques. You have the mediator as because the parties before the mediators are very free to
Yes,
leave
yes.
the room.
That gives my
The confidence,
right.
trust, right? His personality, his gesture, posture, his
Yes,
performance,
yes.
all these qualities involved there, right? So when a young officer is posted there, I think it should be rethinkable. It should be it should be it should be again. It should be thought again, right? So my suggestion, I always speak of that. My suggestion is like that. More seniors lawyers, more senior judges will be posted there. And my one is another suggestion is like that. Give me. I told in the seminar in the High Court division, High Court auditorium, with the presence of many lawyers, senior lawyers. Well, nothing. I need only 200 judicial officers. Give me 200 judicial officers. I develop a mediation system there, and you see how the result is going on.
Yes, yes,
Because
that exactly brings
because
me that exactly brings the next question. Right, the query. Okay, what about the training? Because the mediation is not a just a somebody's natural process or so. What is the training? Because in India, what we are going on, the training of mediators is very important. Training is very important. Just like as you said it, okay, it is not a younger officer may feel a little intimidated or a different feeling when a senior lawyer is arguing a civil case.
even having no training at all,
No,
they're posted there.
so therefore, training is very important. And in India, they made it specifically. They made it very specific. One is a perception. One, a judicial officer may have a perception of going for a settlement. But unless there is a training, you cannot go for it. And training is very important. Very important. Training is an absolute. It is just like it, like an acting. Acting is always being heard that it is a natural flair. It comes out naturally. But there are acting schools because it is absolutely a art which must be learned. The painting, the creativity must be organized. It must be methodical. It must be chronological. So the training gives an individual, a mediator,
Right.
a perception. He may have a natural flair. In India, that has been a very important thing that there has to be a mediator can only be a person who has got a training of 40 hours.
Yes.
And the Supreme Court laid great emphasis while in manual. They said there has to be a training.
Definitely.
There has to be a training.
Perfect.
And you will be surprised that in Supreme Court, the first mediation training was held in 2009, 8 and 9, the earliest one when I was also there. It is despite that I had a training elsewhere also. I was trained in US for mediation, but the Supreme Court said, sorry, sir, you have to undergo this 40-hour training again. I went undergo 40 hours training again. Now, after that, it is only in 2019 that the second batch was trained. So selection of individual and a training has to maintain a standard. Otherwise, that is very important. And I must share as a mediator, I must share two things are important. Training is important, and the ethical values. Ethical values are as important as any other training. The confidentiality and ethical values are so important in the sense that a mediator must disclose all his possible apprehensions. If there is an apprehension of bias, that he must disclose it. So the training is most important. And an important thing where things get in India, it is important. So in training, if going in Bangladesh, training must go.
Definitely, perfectly. Yes, perfectly. Excuse me, I'm adding. Just I do agree with you. 100 on 100. Agree with you. There is no question about it. I'm adding just like we have training, and training must be effective training, right?
Yes.
If training must be effective. For example, after passing the MBBS degree, after getting the MBBS degree, the doctor has to be with the doctor, right? Is interning. We call it internship. So a lawyer, you know, passing after getting the LLM degree or LLB or the being the member of the bar, he has to go the with associate with the very famous lawyer or the very good law firm to have the practical idea, practical experience, right? So in mediation also, I believe this training must be practical, applied training, applied training. Person who has application of mediation or who is a mediator, practical mediator. So being a certified mediator is one thing, and being a practical mediator is another thing, right? So I think uh, definitely you rightly say that training is a must. But I add with you, I want to add with you is a effective training, right? It's
Thank
a
you. Thank you for the
effective
value
training.
addition.
Because
Thank you for this.
I see lots of people. They say they are giving training to the students or to the lawyers like this, uh, uh, with a very big heading or very big poster, right? So after 30 the 35 sorry 40 hours or 20 hours or 1 day 2 days thing, short training, because namely short training course, I don't know how the short training course on going on, how can be beneficial for him, right? Is a fresh graduate is being given is a short course training, is a 1 day or 2 days, how he's taking the this training and getting his certificate, but I think he's not getting the
No,
actual
no,
training. A-
no. These
And with
certificates
this
are
training, I can assure you, with this training, a graduate or a fresh graduate cannot sit with the mediation table with
I
this certificate, with this training.
Judge, I share you our Indian experience. While we are having a training in India, what we do is for 5 days, all
Yes,
the trainees are being taken to a different place. They are away. And at that place,
yes,
there is a from 9 to 5, there is 8 hours per day training.
yes, I know.
Trainers are
Every day
trained
8 hours. You know, I did it. Every day
the
8 hours
trainers
into 5 days, 40 hours.
at the 5. Yes, yes. So those are
Yeah,
there.
I know. I know.
And the second thing is the continuous education. Look, what
Yes,
exactly for a
yes, yes,
mediator is
yes.
there? Mediator is an inter-exchange of ideas. Say like both of us are mediators.
Yes, yes, sir.
I come across a situation where possibly I am filing a Fox pass. Suppose I share this
Yes,
problem with you.
yes,
Possibly you may say,
then,
oh, I came across a close to this problem and I found this solution. So
yes,
inter-exchange and continuous legal education is very important. And this Supreme Court
yes.
mediators, our group is doing this continuous legal education. We are having regular courses with international, we did sports with judges are there, Commonwealth. Fortunate for us, the judges really helped us.
Ah, that's perfect. That's good.
The retired judges and the sitting judges both. We get there is no denying this fact that there is, but it helped it gave an impetus. Now coming to it, because it's an almost time would also be there. There are some questions which I get from.
Talks we have.
Just one thing we want to share.
I'm very impressed. I'm very impressed. Impressed.
Both of us are passionate mediators, so therefore we can continue for talking, and it may be not so. So, what exactly both as a Supreme Court mediators group Nivaran, as well as
Yes.
the Bangladesh International BIMEC can help together, work together while taking this movement. What can we do? One is this: such webinars can be continued. Can we move ahead? If you want training, we can be there, or you whatever you feel like. How
Yes,
can you
yes,
take the move?
yes. Thank you very much for your extending cooperation and also thinking far ahead for me. So it's a big. I also believe it's a continuous learning process, and it should be exchange program, right? We can organize in the COVID situation. We can organize some seminars like symposium on online, and after COVID we can exchange program. We can have exchange program, right? If our mediators, young mediators, may have the chance to visit India, right, to Nivaran, or to watch how mediation is going there, and so this can be. And if you send some participants to come here, right, although you are developed, I believe, so there's a chance for us to go there to have the idea and to have the knowledge, right? So I think it can be very, very effective. And after COVID, and India and Bangladesh is very close, and so it's a half an hour fly time in Delhi, no matter. Okay, half an
Look,
hour. It's
we
very,
have
very, very easily reachable. So we can. Our intention is is the main, right? If you have like these are, if I have these are this, so it is possible, and that will be the very, very good option for us for developing ourselves, and to avoid to eradicate the suffering of the people, because I believe, however, how much the mediation process is developed, they lower the suffering of the people of the season, and it will be beneficial for the, not for the family of the that respondent, but also the benefit of the nation, both the
yes,
countries.
yes. In fact, a mediation movement, it moves around whether it is on a place or a B place. It has to be a worldwide phenomenon. While
Yeah,
in
right.
Commonwealth
Actually,
also,
it's
it
a
has to be
one village.
worldwide.
It's a one village. Yes,
Uh,
yes. It's one village.
Fortunately, in Supreme Court, this Nivaran, we have got almost about 90 mediators, and we have got a large number of very good female ratio. We have gotten almost more than half are female and very good mediators, wonderful mediators. And there are
I know.
some
I know.
trainers
I
also.
know one female mediator from Chennai. She's a full-time mediator in the court.
Ranganathan.
Is it CB Purnima or like this? She is also with BIMAC, right? So we have some connectivity like this. Okay.
Whatever it is. So if
So
you
she
want, we are
she's
there. We are there.
yeah.
There are some mediators who are trained mediators. They do training, online training also. So
Yes,
if
yes.
any case, anytime we go ahead, let's just see about these questions. Some of the same which I framed, which from the audiences it came. Let's see some more questions. Can we take up or?
Okay, okay. Most welcome.
I just received. We must thank Mr. Brian Spears, the president of Commonwealth Lawyers Association. I welcome Brian. I welcome Justice Bala Sundran Rajendran, a judge. A justice. So I welcome him. Judge, there are a lot of questions are coming. And I think
yes, most welcome. Most welcome. I will try my best to respond.
These are the questions which I tried to form on the basis of it and going on. I tried my best, and it was a wonderful talking. And let's take this movement of mediation together, because we have been doing this mediation. The judges have favored us. We have Justice Sikri had come, Justice Korean Joseph has come, the name of the few. We have got a mediation committee in Supreme Court. They have helped us.
Yes.
So
yes, I got the idea. So I pursue
their thought process percolates.
Our seniors
the percolates.
Thing like this. Yes.
Thank you very much percolates.
I got some ideas right from you, right? And that's why the benefit of the webinar. That's the benefit of the webinar on my part, because I have lots of ideas from you that I can I ventilate to my seniors, like this, saying like this. So this is happening in India by setting up this and this. So we can try, sir. So like so, I think it will work. It will work.
Yes, yes. So I must. Before taking leave from Bangladesh, friends, I must say you have got a 50th year of independence, and I must congratulate you, all of you, for having a 50th year of independence. This is 2021, and
Thank
you're celebrating 50th year.
Thank you very much for yes.
So
And
all
India is our best friend too. And I always we the Bangladeshi people always remember India. What the tremendous support they gave us. Always, our Bangladeshi people are very much grateful to India people because in 1971 India support without I have to confess the truth. Without the support of the India, it would not be possible for us to be independent. So we consider India like this, right? So my great salute to Indian people, the Indian nation, and the audience, the Indian audience. You are watching me. My salute to you because without your help in 1971, we cannot be independent. We could not. We could not be independent.
thank you
Yes,
so
sir.
much, Judge. Thank you so much. Now it's time to close.
No, thank you. It's a one. If you permit
Yes,
me,
you want
just a few words from my side. If you permit me.
please, sir, please, Judge.
So I really I feel honored by for an invitation from Nirvana and by you, and I would like to thank Mr. Shantan Krishnan who actually the made the jack. He made the jack with me, right? and I want to thank the person behind the stage who made it possible, and I also congratulate all the audience having patience, giving the patience to hear me, and thanks a lot. And I am really honored. Really, I feel honored by inviting you to talk to something or to share something before you before because you are the most senior men, more senior in profession with more senior professionals, more senior mediators, and I know Supreme Court. I know the Indian Supreme Court is the total collection of the senior lawyers, senior mediators there. So it's a big chance. It's a very good chance for me to be with you, and I really grateful to you all. I just want to close by saying one thing like this. This is the beginning of exchanging our ideas. It will be continued, and for it will be continued for our own interest, for our interest of the litigant people, for our for the interest of our respective nations, respective countries. So thanks a lot again from my side. Thank you.
Thank you, Judge. Thank you, Judge.
Thank you, Judge.
Bye bye. Bye bye.
Thank you.
Thank you.
Thank you, sir. Thank you. Rahul?